Hey there, I'm Sully and welcome to the Gun Club. Today's video is going to be kind of a little bit of a special edition. We're doing something a little different, covering a legal update, a big legal update for those of you in or around the great state of South Carolina. If you didn't know, last week on Wednesday, March 6th, the South Carolina legislature, the House and the Senate, finally passed the HB 3594. We're just going to call that the Constitutional Carry Bill. They've got a much prettier name for it, but we'll call it 3594. Works just as well for me. Now, that bill has a lot of things in it. It went to the governor's desk the next day, and Governor McMaster made very quick work of signing it, as he stated he would do all along. So, for those of us in the great state of South Carolina and anyone near or around, yes, South Carolina has constitutional carry. But what are all the details? Who does it count? Is it only residents? At what age? What weapons? What are the rules? What else is attached to it? Let's go over that, because you know what? There's a lot of stuff involved, and I want everybody to know as much as they can, because as good as this is, and it's a really great bill, they didn't get a lot of garbage attached to it, but as great as the bill is, we all know ignorance of the law is not an excuse, and as law-abiding citizens, we need to know what the rules are in order to be able to play by them. Now, before we get too deep into this, I want to throw out one question that I've gotten directed at me a few times since this passed. And it was pretty much, well, if it passes or when it passes or now that it's passed, why even get a permit? What do we need a permit for? Who cares, about a permit? Couple things, and I'm going to throw this out there. Number one, even though we have constitutional carry here, great. I don't need to have my permit here, but I do have reciprocity in both North Carolina and the Commonwealth of Virginia. They don't have constitutional carry. So if you happen to travel between states, there are some others, but those are the two closest that I know of. Now, Georgia's got constitutional carry also. So if you're only in South Carolina or Georgia, maybe, whatever. But if you ever want to be able to cross the line into North Carolina for any reason, which I do quite regularly, nice to have. Second thing, it does expedite firearm purchases, and we'll talk about that a little bit. Third thing, and this is a big one to me, if, heaven forbid, Mr. Murphy pays you a visit and you end up in a lethal force encounter where you either display or have to use your firearm, when you're talking to law enforcement afterwards, or potentially an attorney afterwards, or a prosecutor, do you want documentation of your knowledge and your training as far as what the laws are, that you're a responsible citizen, etc., etc.? Or do you want to just say, we've got constitutional carry, I can do what I want? That might be nice to know what the rules and the laws are, because as we always preach, not knowing the law doesn't give you the right to break it. So again, being that it could potentially have benefits to you in a criminal or civil trial, do you want to look like the responsible firearms owner or the not so responsible one? Now, don't misunderstand me. I am 100% in favor of this bill, and one of the biggest reasons is we deal sometimes with people who are fleeing bad situations, bad domestic situations. They need to be able to get and carry something now. Under the old system, even if they went through all the training, all the classes, all the background checks and everything, it still took 2 to 3 months for them to actually physically get a permit in hand and be able to carry. Well, that wasn't a real good thing. Now they can expedite it, they can carry without a permit while they're waiting for their permit to come back. They can get the training in a day. There's a lot of instructors who will do emergency classes, especially when someone is dealing with a domestic violence or a stalking situation. Maybe it's a psycho ex. Maybe it's your crazy neighbor. I don't know. But all of a sudden, you want that ability. Well, now you have it, as is your constitutional right under the Second Amendment. However, as much as you can do it, my recommendation personally, and what I'm going to do, I'm going to keep up my permit. Number one, to give me other states. Number two, it makes it easier to purchase, and we all know I love purchasing. And number three, documentation of my qualifications and training. That's why, even as an instructor, I take classes from other instructors. Why? Because, heaven forbid something happens, I want to present myself in the best possible light in court. That being said, we'll talk about some things that are coming out with the new bill and some options that people will have. I won't tell you what to do. You do you, boo. I firmly believe, and I shouldn't tell you how to live your life. I ask the same. Now, let's get into 3594 here. A lot of good stuff coming through. This memo was put out the day after, or the day after it was voted through by the legislature, and it was put out by the South Carolina Law Enforcement Division. We'll just call them SLED. Now, SLED is who issued the permits in the old days and will continue to do so. It went out to all police chiefs, sheriffs, law enforcement officers, and basically was giving them guidance on how to deal with this new change in law. In case you're wondering, this entire PDF is saved on our locals page if you want to go back and download it. If you can't find it there, you can get it on the SC SLED website. If you can't find it there, heck, drop me an email. I'll email it up to you. You can always find out more on my email. Ask me a question, whatever. I'll send you a copy of this. I think it's important that we all know what we're doing. So again, you can find it on locals, find it on SLED's website. You can get it from me directly. Now let's dig into it. It states H 3594 was signed by the governor on March 7th, 2024. This authorizes individuals who are not otherwise prohibited from possessing a firearm to legally possess a firearm openly or concealed without training and without a concealed weapons permit issued by SLED. Prior to that, we had to have our permit. This legislation leaves in place the CWP program that's run by SLED for individuals who wish to continue carrying with a permit. The CWP will continue to give the individual reciprocity with other recognizing states and makes purchasing a firearm from a dealer easier. Every time I've purchased, they always ask me for ID and do you have your permit? It's one real good way of them verifying whose background they're running. That way, the same Karen Jones isn't the same Karen Jones isn't the same Karen Jones. Guess what? This is the Karen Jones. You've got my background on file. You got my prints on file. Now, this went into effect immediately. Sorry, need to take a little bit of laugh at Louisiana. Love you all down there. But folks, Louisiana got their signature from the governor first and passed theirs first. They're having to wait till like June or July for it to go into effect. Here in South Carolina, once Governor McMaster signed it, it's like, gentlemen, he signed it, load him up. Okay. And we did. Now, it allows individuals 18 years and older to carry firearms open or concealed without a permit. 18 and up, big number there. There are no restrictions on guns inside of vehicles. They can be stored anywhere inside the vehicle, open or concealed. Possession of a firearm alone is not a reason to stop an individual. To make a stop, and again, this is to law enforcement, to make a stop, there must be reasonable and articulatable suspicion a crime has occurred. Law enforcement officers cannot conduct a stop solely because a firearm is visible. Now, you're walking down the street, open carrying your full-frame 1911, hey, more power to you. But again, a law enforcement officer can't stop you solely based on that. However, if they've gotten 2 or 3 calls that you're suspicious, they may choose to interact with you. Again, they can't do it just because you have a firearm, because that should be seen as innocuous as your cell phone. A CWP holder or a person carrying a firearm without a permit pursuant to this law does not have a duty to notify law enforcement that they are carrying. In the old days, we had to notify law enforcement anytime they asked for ID that we were carrying and we had a permit. Now, if we weren't carrying, we didn't have to discuss the permit. But again, we no longer have to make that notification. That's a change. Insofar as there is no longer a CWP requirement, the permit holder is no longer required to carry his or her permit or disclose his or her status as a permit holder to a law enforcement officer. Again, that is a change. Firearms are still prohibited in many locations, and we'll talk about those, including schools, churches, law enforcement facilities, including detention or correctional facilities, any place medical procedures are performed, courthouses, public buildings, public meetings, and any place clearly marked with a sign prohibiting the carrying of a firearm. Individuals 18 years and older will now be eligible to apply for a CWP. So if you decide that, hey, this is great, but I still want to have my permit because I like going up the road to North Carolina, whether it be up to Charlotte, or I like going to the Outer Banks or up to the mountains, or go up to Hendersonville for a day trip, that's fine. You can still get your permit. 18 and up is the law here now. This will establish state-funded firearms training that will be administered and coordinated by SLED and CWP instructors. State-funded training. Now, over the next several months, SLED will develop a training program and a list of certified CWP instructors to provide South Carolinians with firearm training pursuant to this law. The training will not be available to the public until they appropriate funding in this year's budget. Likewise, SLED cannot reimburse CWP instructors until the funding is appropriated in this budget. So they're trying to come up with state funding, free funding for classes. I'm all on board with that. I don't know what the curriculum will be, how big it will be, how much detail they'll go into. I can make no representation about how this will be handled. They're putting it together now. However, we'll go on here. The State Law Enforcement Division shall provide a statewide concealed weapon permit training course that satisfies proof of training requirement for the issuance of a concealed weapon permit. SLED may not charge participants a fee of any kind for this training for the concealed weapon permit training course provided in this subsection. SLED may contract with private certified concealed weapon permit training class instructors or local law enforcement instructors to provide the course, or SLED may provide the course itself. Again, so they can contract with private instructors, contract with local law enforcement, do it with their own instructors. Not sure how they're going to do it yet. The training course must be offered in every county in South Carolina at least 2 times twice per month. If demand exceeds the capacity of the training course, if any, in any county, SLED shall provide additional classes until there exists a sufficient number of classes offered at least twice a month to meet demand for training in each respective county. If SLED is unable to contract with an instructor or a law enforcement agency, SLED must then conduct the class for that county. The program does not prohibit any certified concealed weapons permit training class instructors from providing their own training classes and charging participants a fee. Now, this is where some people were questioning me. How much is this going to hurt my business? Folks, first off, I don't make the vast majority of my income from teaching CWP classes. On the other side of that coin, I am not worried about SLED or law enforcement competing with me because, again, what I do is mostly friends and family. I'm fairly reasonable on the cost. Yeah, they could get it free with the state. I don't even know when they're going to come out with this. They're going to come up with a program and everything else. It is what it is. I hope they come up with a really good program. I hope they come up with a fabulous program and blow me out of the water. On the other side of the coin, I've seen some places that try to shortcut training and try to do it. And if they're having to do all these classes statewide, it doesn't say what the maximum number of students in the class is going to be. Let's say they have to do it twice per month, and so they're running 40-person classes. Hey, great. They may do it at local community colleges and go through the legals. How many firearms will they handle? Will people be able to bring their own firearms in and go over how to work on them or tinker with them or how to disassemble them if they're not familiar with them? Again, I'm not worried about them digging into my business. Might hurt a little bit, maybe not. Who knows? People may decide that since they like their constitutional carry so much, they now want to get their permit so they can go out of state with it. They never carried before, but now that they do, they may like having it around. Who knows? Now, this new law does establish increased graduated penalties for unlawful possession and carry of a firearm. A person violating the provisions of Section 1623-20 is guilty, and it goes through the penalties here. This is primarily a location where you can and cannot carry, i.e., the whole schools, daycares, etc. list we're going to go through. So again, someone who's violating the provisions, carrying illegally, can get a misdemeanor for the first conviction, $1,000 and not more than 1 year fine, a misdemeanor and up to 3 years for the second offense, and a felony and up to 5 years for the third or subsequent offense. So again, there's some places we're not allowed to carry, but any place we could carry before, we still can carry. This does not change our locations at all that we're allowed to carry in. It additionally establishes a felon in possession of a firearm graduated mandatory minimum penalties. So for this one, it's unlawful for a person who has been convicted of a crime punishable by a maximum term of imprisonment of more than 1 year to possess a firearm or ammunition within this state. Those are our prohibited possessors. For the purpose of this section, a crime punishable by a maximum imprisonment of more than 1 year does not include any offense in the state or any other jurisdiction pertaining to antitrust violations, unfair trade practices, restraint of trade, or similar offenses just relating to the regulation of business practice. However, it also does not include any offense classified by the laws of this state or another jurisdiction as a misdemeanor and is punishable of a term of 5 years or less, or any crime for which the conviction has been expunged or set aside, or for which a person has been pardoned or has had civil rights restored, unless such pardon, expungement, or restoration of civil rights expressly provides that the person may not ship, transport, possess, or receive firearms. Now, this, again, we need to know the law. Prohibited possessors, if you have a question, I would strongly suggest contacting your local either law enforcement agency, your local solicitor's office if you're in the state of South Carolina. Make sure where they stand on this, because again, other similar offenses is the way it's worded. So again, go from there. Now, someone who violates the provisions of this section is guilty of a felony, and upon conviction must be fined not more than $2,000 or imprisoned not more than 5 years, or both. For a first offense, must be imprisoned for not more than 5 years. If we get into second offense, mandatory minimum of 5, but up to 20. Third or subsequent offense, mandatory minimum of 10, but not more than 30. They're going after prohibited possessors. And, I really love this side. And the reason I do, I've got to say it, folks. If the person is a prohibited possessor, if they want to take the steps to get their record expunged and their rights removed, and I know a lot of good and decent people out there who made stupid mistakes when they were younger, who may be prohibited possessors. There could be the, wonderful young girlfriend who takes responsibility for the pills that were really the boyfriend's. There could be the, young guy who takes responsibility for what his girlfriend did because, young guys do stupid stuff for chicks. On the other side of that coin, though, the people who are prohibited possessors, either A, work on getting your rights back, or B, I'm sorry, can't do it. But the vast majority of prohibited possessors are the ones we see with problems. They're now janking up the penalties on that. I can deal with that. It also establishes an increased penalty for a person who commits a crime involving a firearm and does not possess a CWP, and establishes an informative statewide advertising initiative. Now, this is another little side benefit to having your permit. A person convicted of committing or attempting to commit a crime involving a concealable weapon in violation of an offense listed must be imprisoned not to exceed 3 years. A term of imprisonment imposed for violating this section must be served consecutively to any term of imprisonment imposed for the underlying offense and may not exceed the actual sentence imposed for the underlying offense. Okay, what's that mean? Let's put it in English. If somebody commits or attempts to commit a crime involving a firearm, that's any one of these, robbery, armed robbery, those type of things, they get a extra penalty added for the use of the firearm in it, that if they actually have a valid permit to carry, they can actually not be charged with that secondary offense. Why would that happen? Well, they're trying to still have an incentive for people to be good little boys and girls, to be responsible adults. So you get in a situation, it's a heated battle. Maybe you're right, maybe you're wrong. Maybe you did something stupid, you brandish or you threatened or you put someone in fear of their safety. And so you exposed your firearm, whatever the case may be, in a heat of moment. Well, guess what? You probably will get it a lot easier, get off easier than if you were not a permit holder. Because it shows that by getting a permit, you generally try to be the law-abiding citizen. And you had a bad day, yes, you can still get your original offense charged, but they're not going to have that little 3-year kicker on the end of it. So, again, they realize that even permit holders can do stupid stuff, but it's sort of a discount on the crime for the permit holders. Makes sense. Now, the additional punishment may not be imposed unless the indictment alleged as a separate count that the person was in possession of a concealed weapon without a valid permit during the commission of the crime and conviction was had upon the additional count of the indictment. The penalties prescribed in this section may not be imposed unless the person was convicted and indicted of the underlying crime. So again, you're in an assault or aggravated assault situation, they, give you, the permit, or you have a permit, therefore you may not get an additional charge. The State Law Enforcement Division will develop and document and distribute to retailers that are federally licensed to engage in the business of dealing in or selling firearms in South Carolina. These retailers shall provide the documentation to gun purchasers, informing them that the law provides a process for gun owners to obtain a concealed weapon permit, allows law-abiding gun owners to carry their weapons without a permit, and the document will inform gun purchasers that if an owner commits a crime involving a weapon and they do not have a permit, there may be an additional charge. So, again, nobody thinks they're ever going to be charged with anything, but if you get in a stupid, again, assault at the local bar and you're wearing a weapon and you got a permit for it, you don't get the extra charge. Same thing happened, you don't have a permit, they can add an additional consecutive 3-year sentence onto the end of it. Food for thought, folks. SLED must conduct a regular statewide marketing campaign to inform South Carolinians that South Carolina law provides a process for gun owners to obtain concealed weapon permit and allows law-abiding gun owners to carry their weapons without a permit. The campaign must inform gun purchasers that if a gun owner commits a crime involving a weapon and the owner does not have a permit, there may be an additional criminal penalty for the underlying offense. So there's a fourth little benefit there. Again, no one ever thinks they're going to get charged, but hey, could be a benefit. Let's move on. Firearms in vehicles. A person who is not otherwise prohibited by law from carrying a firearm may lawfully store a firearm anywhere in their vehicle, whether occupied or unoccupied. Now, we're going to hold on that one for a second. That's what the law says. Good common sense says if you're going to leave a weapon in your vehicle, make damn sure it's secure. Please, folks. Guns stolen out of vehicles are a huge problem, not just here, everywhere in the country. And if you've got, 3 Glock stickers, 2 SIG stickers, and a PSA sticker on the back of your car, guess what? Someone breaks in and they get your gun out of the glove box or whatever that's not locked, not secure in any way. Your gun just became their gun. And unfortunately, we see that problem all too much. So again, you can have it anywhere in the vehicle. Please make sure it's secure. Furthermore, this law establishes a requirement. An owner or other person who is lawfully in possession of a firearm, shotgun, or rifle in this state who suffers a loss or theft of such weapon shall report within 10 days of discovery the loss or theft of each weapon to the appropriate local law enforcement agency, whether it's PD or Sheriff's Department, which would have the appropriate jurisdiction where the weapon is located. In addition, the facts and circumstance of the loss or theft also must be reported to which the agency the report is made. Again, you have to do this within 10 days of discovery. So right there up on top, 10 days of discovery. Now, if it's your hunting cabin and someone broke in over the winter time or over the summer, and you're just getting there and find your deer rifle missing, okay, you've discovered it today. It may be gone 2 months. You need to report it within 10 days of discovery. And that's a big one there. It documents here, adds clerks of court and public defenders to the list of officials who can carry a firearm anywhere in the state. However, they cannot carry a concealable weapon into a local or state correctional facility. That doesn't affect too many people on here. Now, let's go over our prohibited locations. I told you we'd get to that before. Any law enforcement, correctional, or detention facility, a courthouse, courtroom, or other publicly owned building, whether owned by a state, county, municipality, or political subdivision, where court is held or during the time the court is in session. Any polling place on election days. That's one that can get people in trouble, because they don't go to vote all the time. They don't think about it. They're running their errands and, oh yeah, today's the day we've got to go vote in the primary or whatever. Guess what? Make sure you leave it in the car. Thank you. An office of or business meeting of a governing body of a county, public school district, municipality, or special purpose district, like if you have a water and sewer district or something like that. The next one is any school or college athletic event not related to firearms. Technically, because a college event related to firearms, you're allowed to have firearms on the property. Generally, to me, school and college, I just put it as off limits. The only reason that little caveat is there is because that way we don't have to arrest the riflery team when they're out doing riflery stuff at the school, or the biathlon team or whatever. Be kind of hard to arrest them when they're bringing their guns to riflery practice. Daycare's facility, preschool facility. Keep in mind, if you're going inside to pick up your kids at the daycare, can't bring it in. Sorry. Any places where carrying of firearms is prohibited by federal law. Number 8, and this is interesting, a church or established religious sanctuary, bullet point, unless express permission is given by the appropriate church official or governing body. Now, Joe Smith works at or goes to church at church up the road here. He's part of the church safety team. People know that there are 3 or 4 people there on the church safety team who are routinely carrying. We do a lot of work with churches, helping with classes and stuff, so I'm all on board with that. However, what happens if someone in the congregation knows that all these other folks are carrying and they want to carry too? They can't until they get permission. Again, make sure we stay within the laws. Now, any hospital, medical clinic, doctor's office, or any other facility where medical services or procedures are performed unless expressly authorized by the appropriate entity. Again, chances are I don't carry to the doctor's office or going to hospitals or things like that. I will say that that's also one of those things where, now my doctor, he's got his permit. I joke about it with him that, I have to disarm to come and see him. Meanwhile, I know he's got his permit. We've laughed about it, but it is what it is. Residence or dwelling of another person. Again, you're going to your buddy's house, your friend's house, your girlfriend, whatever. You can't carry it in their house without their express permission of the person in legal control or possession of the residence. Now, your ex-girlfriend or your girlfriend doesn't want you carrying, or she lives with her folks and her folks don't want you carrying, great reason to have a good safe in your car to secure it. And lastly, any place marked with a sign prohibiting the carrying of concealable weapon on the premise. It talks about that signage, has to comply with section 23, 31, 235. You can look that up in the state SC SLED website. I think we've also got a picture of it on our site. Again, we need to understand someone who violates this, whether the violation is willful or not, only may be charged with basically a simple trespass and not be charged with a violation. That's it, folks. And once again, congratulations. South Carolina, I'm really glad that we got this. I'm happy that we made it this far. The only way to keep making progress like this, quite honestly, is to prove that we are responsible firearm owners, to prove all the naysayers wrong, all the people who say, OMG, you're letting 18-year-olds carry, OMG, open or concealed carry, OMG, there'll be blood in the streets, there'll be shootouts on Main Street every night. Right after concealed carry passed in Ohio, a year later, crime is down in 4 of the 5 major cities significantly. Many places that have gone constitutional carry, concealed carry, they put these laws in. Guess what, folks? Crime gets better. Why? Because we know that law-abiding citizens are not the problem. On the other side of that coin, we need to make sure that we stay not the problem by doing right. We need to be the responsible citizens that we know we are. Folks, I hope you've enjoyed this. I hope you got something out of it. If you did, please go ahead, give me a thumbs up. Send it out to your friends. Follow us if you're on Rumble. Hit the like button on YouTube, little thumbs up thing there. We're doing this to try to help educate not only people in South Carolina, but visitors to South Carolina. If you want copies of this document, we've got it posted up on our local site. You can see the link right there. Thank you very much. Y'all have a wonderful day. Be smart and be safe.